Kentucky Senator Mitch McConnell is not the Senate. This is administrative constitutional law, procedural constitutional law, obstruction of legislative processes. McConnell versus Justice. Now, it's Constitution 101, criminal law. A lot of the concepts come from Marbury versus Madison, but it's summed up in the criminal law and the charge of obstruction of justice. I mean, this is like, I don't understand how you could be more textbook obstruction of Congress than this. Mitch McConnell clearly never had the power to do any of the things he was doing, and it wasn't his responsibility to be involved in what he was doing, but he took it and nobody said anything to him about it, which is now the Senate. What the Senate actually is, it's two Senate, I shouldn't say reps, it's two senators for each of the 50 states. It's supposed to be this meeting house of people where, where the states, and keep in mind, it's not supposed to be parties represented here, it's supposed to be states represented here, where they go and they fight for, to bring stuff back to their state, not for some party or one party or another, but they fought for their state. And you can't really see there's any of that anymore. It's just party politics all the time. But so in order for the Senate to make a decision, it has to be the two senators from all of those states. So this is the Senate. Mitch McConnell is in this picture of 100 people. It's not a picture of Mitch McConnell because Mitch McConnell is not the Senate. The Senate only acts by all of those people voting. If all those people don't vote, or a quorum at least, 50 plus one, have to vote, that's the Senate making a decision. Otherwise, if Mitch McConnell is just saying, we're not going to schedule a vote anytime within 10 months, he doesn't have that kind of power. That's obstruction of justice. He doesn't have any, there's nothing that the Senate is doing that's more important over the course of 10 months than seating a Supreme Court justice. This is not even close to possible. The only reason he did it was to take power, was to put a Republican appointed judge on the seat, a Federalist judge, onto the Supreme Court. And then he did the same thing with the 113 judges. He held up their nominations because he was hoping that they would get a Republican president, and somehow they fluked through one, and managed to get these, what they were not eligible to do, these 113 seats, and Neil Gorsuch on the court, or Amy Coney Barrett, depending upon how you want to think of it, and the nominations. The appointments clause, it says in the Article 2 of the presidency, which, the presidency is got its own branch. The one senator is just one out of 100 people. The president is the president. So he shall nominate, meaning the president, by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, and judges of the Supreme Court. Now, that's usually just ambassadors, agency heads, and judges of the Supreme Court and the judges of the Circuit Court. Those are supposed to be nominated by the president, not by the Senate. In fact, the Supreme Court was quite Bucky versus Vallejo and a bunch of others. They were pretty unequivocal. At no point and Taft also, although he was a former president who became a Supreme Court justice, so obviously he had some kind of feelings on that. Judges are not supposed to be, or the Senate's not supposed to be picking judges. The president is. They're just a check in case the Senate happens to, or if the president nominates Bozo the Clown, and Bozo the Clown only has his law degree, isn't a member of the bar, the Senate has to say, Bozo, you've been you're a great clown, but you're not admitted to the bar, and we need you to be admitted to the bar to become a Supreme Court justice. So that's a no from the Senate on, and they would have to take a vote to say no. Neither Mitch McConnell nor Joe Biden nor anyone else has the power to keep the president's appointment from coming to the floor. It's supposed to come to the floor. There could be some leeway towards the very, very deep end, like January or December before, a new president comes in. But most of the time, you're just supposed to seat them because that's the way it kind of works right now. Now, what the charge is, 18 U.S.C. 1505, obstruction of Congress. Whoever corruptly influences, obstructs, impedes, or endeavors to influence, obstruct, or impede the due and proper administration of the law under which any pending procedure is being had before any of the due and proper exercise of the power of inquiry, which any inquiry or investigation is being had by either House or any committee of either House or any joint committee of Congress shall be fined under this title and imprisoned not more than 5 years. So the baseline charge for doing what he did was 5 years. And keep in mind, with 113 counts, which he admitted to, he's already admitted to this on video. So that would be 113 counts of not more than 5 years. And depending upon how the judge decided to think about it, it's either all taken care of in 5 years or it's, literally life imprisonment. Hard to stomach. It's 113 judges, 113 judges that were blocked, and the Supreme Court swing vote, which means that they seized control of the Article 3 branch. And he pretty much tells you, he's like, I'm trying to make sure that Obama doesn't do what he's supposed to do, use his constitutional powers. And so he did 113 judges in the control of the Supreme Court. And he explains it quite well. I mean, he really lays out his intent, and it's sort of the definition of corrupt intent. So let's hear it, and let's hear it from his own lips. So you don't have to believe me. Let's hear it from Hannity and.
Well, let me tell you what this book is about. This book is about the most long-lasting contribution that Donald Trump and Senate Republicans have made for the country, and that is putting young men and women who are strict constructionists, who believe the job of judge is to follow the law, on the courts. We did our 50th Circuit Court judge just yesterday. Sean, to put that in perspective, Barack Obama did 55 circuit judges in 8 years. We've done 50 in 3 years, and we have at least a year left for sure. We're going to do more. 1/4 of the circuit judges. Remember, most cases don't make it to the Supreme Court. Most complex litigation never makes it beyond the circuit courts. This has been the most long-lasting, important contribution the president could make well into the future, far beyond his tenure in office. So we'll have a judiciary more inclined not to make it up on the fly. You know, President Obama said he wanted to appoint judges who had empathy. Well, you know, that makes great sense if you're the litigant before the judge for whom the judge has empathy. Not so good if you aren't.
Let's talk about the issue has come up. Let's say somebody were to retire at the end of this year. leading into the summer. You have been very clear, if the president appointed somebody, you would follow through on that nomination.
Absolutely. We definitely would do that. And this paperback that we were just talking about, the president's foreword is about judges. My afterword catches up what's happened during the Trump administration on judges, because my memoir came out 3 years ago before the president was elected. What we've done here, the president and I together with this paperback that you've shown on the screen, is to talk about how the Judge Project came about, how it went forward. If you were to recall, Sean, the most important decision I've made in my entire political career was not to fill the Supreme Court vacancy when Justice Scalia passed away. That was the beginning, and now we've got an exclamation point here after 3 years that we thought the public would be interested in reading about, and that's why the president and I collaborated on this paperback.
I was shocked that former President Obama left so many vacancies and didn't try to fill those positions.
I'll tell you why. I was in charge of the of what we did the last 2 years of the Obama administration.
I will give you full credit for that. And by the way, take a bow. All right, that was a good line.
No, it's not funny at all.
Let me tell you what this book is about.
So, I mean, the guy basically, you know, he goes through and he tells you all the reasons why. He says that, you know, he wants to control the law by, you know, they placed a whole bunch of circuit court justices because it doesn't usually get to the Supreme Court. Yeah. So, you know, he's trying to. Okay.
Let me tell you what this book.
Mitch McConnell just won. He's a senator from Kentucky. He's one guy out of 100 senators. So here again, this is the difference between what Mitch McConnell says and the law. Even though McConnell says a lot of things that are right, the Senate does have the right to act as a check on the president's power. The Senate does, but Mitch McConnell is not the Senate, nor is Charles Grassley. If they do not allow a missive, like it's a constitutional process that starts when Obama sends over the appointment over to the Congress, over to the Senate. So once he sends it to them, it's supposed to get completed. And the Senate can, dilly-dally and decide in like 2-3 months or whatever, take its time, do some research, but it's supposed to move it through most of the time, unless they find something. It's the default is that they're supposed to go where they're supposed to go. The president has the power to make those appointments, not the Senate. The Senate is just supposed to provide a check on those appointments, nothing else. He usurped that power, and he essentially became the selector of who would be the Supreme Court nominees. Yeah, he gave Trump a couple picks, but no one thinks that Trump really picked those people. The Federalist Society did.
Majority Leader.
I'm going to proceed on my leader time.
Without objection.
Mr. President, the next justice could fundamentally alter the direction of the Supreme Court and have a profound impact on our country. So, of course, the American people should have a say in the court's
In the
direction.
Constitution, it talks about the American people. I was a say.
It is the President's constitutional right to nominate a Supreme Court justice,
specifically,
and it is the
against
Senate's
what they were
constitutional
trying
right
to
to
do.
act as a check on a president and withhold its consent. As Chairman Grassley and I declared weeks ago and reiterated personally to President Obama, the Senate will continue to observe the Biden rule.
There's no such
So
rule.
that the American people have a voice in this momentous.
The Senate never,
The American people may
can't
well
set
elect a
those kinds of
president who
rules.
decides to
I
nominate
don't think he did. I
Judge
don't
Garland
think that
for
Biden
Senate
will
consideration.
this anywhere on
The
paper.
next president may
except,
also nominate somebody
Mitch
very
McConnell's
different.
feelings.
Either way, our view is this. Give the people a voice in filling this vacancy. Let me remind colleagues of what Vice President Biden said when he was chairman of the Judiciary Committee here in the Senate. Here's what he said. It would be our pragmatic conclusion that once the political season is underway, and it is, action on the Supreme Court nomination must be put off until after the election campaign is over.
It's not, the election season is.
That is what is fair to the nominee, he said, and is central
October,
to the process.
September.
Otherwise, it seems to me,
May,
Chairman Biden went on,
it's not even close.
we will be in deep trouble.
It was a full year before the
as
end
an
of
institution.
Obama's term. Of course.
Others may
Honestly,
fret,
if it
he
happened in
said,
November, I'd have been like,
that this
okay.
approach would leave the court with only 8 members for some time.
Do what you did.
But as I see it, Chairman Biden said, the cost of such a result, the need to re-argue 3 or 4 cases that will divide the justice 4-4, are quite minor
Biden talked
compared
about
to the
this.
cost that a
Never did
nominee,
it.
the president,
Did it.
the Senate, and the nation would have to pay for what would assuredly be a bitter fight, no matter how good a person is nominated by the president. Chairman Joe Biden. Consider that last part. Senator Biden said that the cost to the nation would be too great no matter who the president nominates. President Obama and his allies may now try to pretend this disagreement is about a person.
So,
but as I just
not
noted,
objecting
his own
to
vice president made it clear it's
character of
not.
Merrick Garland. He just.
The Biden rule reminds us that the decision the Senate announced weeks ago remains about a principle,
The Senate
not a person.
didn't
About a
announce
principle,
anything. So they can't announce
not a
anything
person.
until it has a vote.
It
Mitch
seems clear
McConnell
that
announced
President
it.
Obama made this
They weren't even in
nomination
session at the time.
not with the intent of seeing the
a
nominee
lie.
confirmed, but in order to politicize it for purposes of the election.
Politicizing it by trying to nominate
This
a
is the
justice.
type of thing
So he's supposed
then
to go
Senate
against the
Judiciary
Constitution.
Committee Chairman Biden was concerned about. The exact thing Chairman
Oh,
Biden
so
was
he's
concerned
just
about.
doing it for.
The Biden
He
rule
wants to.
underlines
he
that what the
believes in the
president has
leadership
done
of
with this
Joe
nomination
Biden.
would be
So
unfair
he's
to any
going to
nominee. And more
follow
importantly,
his
the
words.
rule warns of the great cost the president's action could carry for our nation. Americans are certain to hear a lot of rhetoric from the other side in the coming days.
Yeah, but you're
But here are
blocking
the
Supreme
facts
Court justice
they
without
should
your
keep in
power.
mind.
No power to do so.
The current Democratic leader said the Senate is not a rubber stamp, and he noted that the Constitution does not require the Senate to give presidential nominees a vote. That's the current Democratic leader.
I mean,
The
that's
incoming
his
Democratic
opinion,
leader
but
did not even wait until the final year of George W. Bush's term to essentially tell the Senate not, he said, not to consider any Supreme Court nominee the president sent.
that didn't happen.
The Biden rule supports what the Senate is doing
You might have
today,
said that, but there's no seat came up.
underlining that what we're talking about is a principle and not a person. So here's our view. Instead of spending more time debating an issue where we can't agree, let's keep working to address the issues where we can.
Yeah, just forget about
We
it.
just passed critical bipartisan
I'm not going to
legislation to
agree
help
to
address
anybody you put up,
the heroin and
so
prescription
just stop
opioid
talking
crisis
about
in
it.
our country.
No Supreme Court justice
Let's
for
build
you,
on that
Mr. Obama.
success.
So let's just move on to something
Let's keep
else.
working together to get our economy moving
Let's
again
work together for the
and
economy,
make our
even
country
though
safer,
I've literally
rather
said
than
my number
endlessly
one
debating
priority
an
was
issue where we
keep you
don't
a
agree.
one-term president. Let's
As we
work
continue
together.
working on issues like these,
But don't worry
the
about the
American
Supreme
people
Court
are
judge.
perfectly
Don't worry about your power
capable
for that.
of having their say
But
their
we'll
say
work together on other things
on
because
this issue.
I said I wanted to get you out of
So let's give them a
office.
voice.
I would refuse to vote for
Let's
anything.
let the American people decide.
Let's let the American people decide, even though judges aren't elected. So
The Senate will appropriately revisit the matter when it considers the qualifications of the nominee the next president nominates.
the next
Whoever
president, which ended up being Donald
that
Trump.
might be.
Majority Leader.
I'm going to proceed on my
Senate Majority Leader vetoes President Obama's Supreme Court pickup. The Senate only takes actions through actual votes. So by refusing to allow hearings, Kentucky Senator Mitch McConnell essentially vetoes President Obama's Supreme Court Merrick Garland, who he's not a partisan. So he vetoed him because he decided. Mitch McConnell tells you the story. He woke up one day, he heard that Scalia died, and he's just thinking about it. He's like, no, we're not going to have any hearings. And he tells the story about how he personally makes that decision. So he made the decision all by himself without any of the rest of the senators. Then later they got together themselves without any of the Democrats and not on the floor and decided there's not going to be any hearings because they're not going to have any presidents, any Democratic people put into Scalia's seat because they didn't want to give up control of the Supreme Court because they wanted to control the Supreme Court with activist judges. This activist judges on the liberal side, I don't see. I've seen a couple of them in several of the circuits where, it just seems like they're going after things which don't follow precedent. I would say that the court is, just to be clear, the Constitution makes no mention of Senate Majority Leader. Senate and the Supreme Court has ruled on this about the Senate's rules versus constitutional missives. There's no competition. Like constitutional missives, which the Appointments Clause is way overrides any of the Senate rules. United States versus Ballin said that. Marbury versus Madison said, I mean, and that's even more strong because obviously it's congressional bills are stronger than Senate rules. But Marbury versus Madison established judicial review and said even if when he removed parts of the Judiciary Act that they can remove certain parts of certain bills, the courts can't. But because the Congress can't pass laws over the Constitution. Certainly the Senate rules don't pass over the Constitution, and Senate Majority Leader is not only not a constitutional position, but it's really a party leadership position, which has nothing to do with the Constitution. It's literally an external membership group. Republican Party, the Democratic Party, which both of them do, but there's nothing in the Constitution about parties or what you can do with parties or whatever. So when they say that, it's split membership or whatever, there's nothing following in the Constitution. Fantastic anyway. But Grim Reaper obstruction brag. If I'm still the majority leader of the Senate after next year, none of these things is going to pass the Senate, the Kentucky Republican told a small crowd in an event in his home state Monday. They won't even be voted on, so just think of me as the Grim Reaper. The guy is going to make sure that socialism doesn't land on the president's desk. So, I mean, he fell through. I mean, he slowed the progress of Congress. Pelosi and company, and even the previous Congress before that, when it was all Republican and they had the whole kit and caboodle, Mitch McConnell's Congresses, where he has power, they're the slowest Congresses in American history by far, because he just, no ideas of their own and just refused anyone else's ideas to change the country. Nothing other than tax cuts can go through. No one other than Republican judges can go through. Otherwise, it's a big deal. Like just complete and utter refusal to do any of their own jobs, to vote for anything unless, it's something that their, overlords, and, which is by money, allow. And up to and including violation of the Constitution deliberately. Definition of Senate Majority Leader, Senate.gov. Senate Majority Leader. Although party floor leadership posts carry great responsibility, they provide few specific powers. Instead, floor leaders have largely had to depend upon their individual skill, intelligence, and personality. Majority leaders seek to balance the needs of senators of both party and to express their views fully on a bill with the pressures to move the bill as quickly as possible towards enactment. These conflicting demands have required majority leaders to develop skills in compromise, accommodation, and diplomacy. Lyndon Johnson, who held the post in the 1950s, once said that the greatest power of the majority leader was the power of persuasion. Now, that said, Lyndon Johnson was known for putting people in headlocks. I don't know about metaphor. I think it's mostly metaphorically, although I wouldn't put it past him. But he was, he was just a tough guy in the Senate, and it really carried over and did well for him in the presidency. But they don't have inherent powers, and they're not supposed to be like blocking. It's disgraceful to even think about them blocking appointments clause. Now, Judge Garland was the longest nomination without hearing in history. It was 293 days. That's almost a full year. And what else would, what else was the Senate doing at the time? The previous record was Robert Bork, the guy who, and it's a big thing in Republican circles. They talk about, getting borked is just this unfair process by which somebody who's super duper qualified, has all the right credentials, and is just for no apparent reason not pushed forward to the courts because the Democrats want to make it super political. Except that Robert Bork was during the Saturday Night Massacre. like the Republican Attorney General said, I'm not firing a special prosecutor because it appears, Mr. Nixon, that you were involved in a burglary. So it should be investigated. And even though they knew something about it, then the next guy resigned. He wasn't going to fire him because, he knew about it, but he didn't want to stop justice on his way out. And then they got to Robert Bork. He's like, yeah, you know, you're clearly just trying to cover up your crime, Mr. President, but I work for you and I'll help to cover up the burglary you ordered into the DNC headquarters. And then to reward him, I guess, Ronald Reagan later nominates him to the Supreme Court, expecting the guy who fired the investigator who was investigating the burglary into the DNC's headquarters, the one investigating the president who had ordered a burglary, that guy fired the investigator, the cop who was investigating him, and then thought that somehow the Democrats were going to want to vote for this guy who was arguably an accessory after the fact. Arguably, I mean, it's definitely obstruction of justice. Robert Bork actually should have ended up in jail for his part in the Watergate thing. He never should have fired the special counsel because there wasn't any cause to fire them. And there was really cause for, if a president orders a burglary, the Department of Justice is supposed to figure out something to do other than help cover it up. So it was the longest nomination without hearing in history, even longer than this guy Bork, who was, so this is kind of the stuff we talked about before, March 16th. So it's a long time rest of the year. And then he just got blocked from March 16th on. They just arguably a criminal. So we see here, and this one's actually even a little bit short. It's actually twice as high as this, but it wouldn't all fit onto the page. Oh, it actually scrolls off this page, is what it is, because it's 293 days, and he was in an election year, but he was very early in the election year, like March or April, so he went all the way through till January, and the Senate never got around to hearing his case. Well, it must have been a real busy Senate. But no, Kentucky Senator Mitch McConnell set another record for the least productive Senate in American history, although being the overachieving at refusing to do his job, he once again grabbed the title of least productive Senate in American history. So congratulations, I guess. And then you see this is an election year, and then, he says, let the voters decide. But over here, he doesn't want the voters to decide because he figures that, Trump is going to lose. So he jams through Amy Coney Barrett because he doesn't know if it's going to be the last chance he gets, even though it makes him look like a complete hypocrite and completely turned around the exact same thing he had said less than 4 years before. But it was just some kind of excuse. He was denying Obama his pick, not doing it for any sort of moral reason or let the people decide. It became obvious that he did it just for more power, which is corrupt. Refused to hear him. Mitch McConnell, he actually left the court with a 4-4, which meant that some things they couldn't even overturn. They couldn't even overturn circuit court decisions because they were gridlocked. If they didn't manage to break the gridlock, the swing vote, and there's also an entire circuit which doesn't have any oversight, or I guess they assigned it to someone else, but it makes for a huge workload. When Scalia died, it was 5-4. And it was a very conservative court. Scalia, one of the strongest on the court. If Garland gets on in the place of Scalia, then it becomes a left balance court. and it's 5-4 that way. But Mitch McConnell couldn't have that because then I guess they were worried about maintaining power, and even despite tons of corruption. This is the McConnell court, and even this is a little short. It needs the extra red spot since it's now 6-3 and not just 5-3, which is what I'm showing here. Oh no, it is. It's 6-3, and so the liberals, even if somebody else comes over, don't have much of a. It's not much of a choice. It's not much of a help. The one extra judge isn't going to help because there's still going to be 5-3 decisions, so or 5-4. So you can't. I mean, pretty bad. And then this was a court that was chosen by the actions of Mitch McConnell.